right, first off, I'm thrilled to be here for the second year and delighted to have DISA give the opportunity. But we have a lot to cover, and when you get the slides, you're going to also have an appendix to it so that the things that we reference, you'll also have the core issues, because this is a pretty meaty topic that Dr. Sample and I are going to present, and we'll know that we want to give you some takeaways to look at it. I will obviously know, and you all know, how many struggle with cannabis testing in their programs today? Okay, yeah, we're going to walk through it. I'm not going to pretend it's easy, but we're going to do it. Okay, so this is the two of us. Okay, this is for those of you who know, I am an attorney. I'm not your attorney, so people like me to say this. And for those of you, since many in the room, I am your attorney, you know who you are. Okay, here's what we're going to cover. We're going to look at an overview. We're going to take a case study to give you sort of a sense of how it works. Not just what the laws are or what the positivity rates, but kind of look at what's really happening on the ground. And what that's going to sensitize you to is the fact that every state is different. Don't ever think Washington's like Oregon. It seems like it should be, but it's not. We're going to talk about, this group has a lot of what happens with impairment. What are the safety-sensitive concerns today with cannabis use? We're going to give you the laws on a state basis, give you a little update on what the federal developments are, and then, of course, we're going to tell you some tips to how to currently develop an effective policy for marijuana with all of these differences. And then, of course, we'll have some opportunity for questions, and both Dr. Sample and I will be out during the timing. As an unashamed plug, the one thing we're not going to talk about is CBD, which, how many are interested in CBD? That's fine, so you can talk to Dr. David Kuntz from CRL and myself in the next session, and we'll go through all of that. DISA thought it was such a big topic that we needed to split these two up, so shameful marketing, shameful. Okay, so let's give the obvious, and I need to say this every time. Marijuana is federally illegal. It is a Schedule I drug. So how many people here have federally regulated employees, DOT drivers? Okay, all of what I'm going to talk about doesn't pertain. All this state law stuff, you can ignore it. You can't ignore it for your non-DOT population, but there is no accommodation for, currently as we sit today, only today, I don't know what will happen in the future, but there is no accommodation for any type of cannabis use under the federal program. So when I talk about Washington, Oregon, Massachusetts, and you go, what about my DOT drivers? It is not applicable. Nothing has changed. And that's not a legitimate medical explanation. Okay, so this is all non-federally regulated testing. So let's look at the numbers, just so you're clear of how ubiquitous this is. We have 33 states, plus DC, plus 3 US territories that have passed what I'm calling comprehensive medical marijuana laws. That means that there is usually, taking aside California, cardholders, there's qualifying conditions, and we're going to talk a little bit about that. But out of 50 states, 33 of them have it. You add on to that 14 additional states which have instituted low THC, high CBD laws. That's what we're so used to, and that's what people are struggling about for CBD usage. One state has only industrial hemp, or with the passage of the 2018 Farm Bill, it's now just hemp. We've shortened it. Just like Beyonce, it's just Beyonce. And then 11 states, Washington, D.C., and 2 U.S. territories, Commonwealth of the Northern Mariana Islands, for those who are the trivia, as well as Guam, have recreational marijuana. None of them are the same, but we're going to walk through them all. But that's our overview. That's the numbers. If you want a map, you can see where it goes. I didn't put the territories on. But you can see that Idaho and South Dakota are the only ones with nothing. And the reason is Nebraska is white, because it does have a hemp law, but does not have anything else. You can see some geographic trends, though those are falling apart. So, in order to sensitize this, we're going to talk about 2 case studies. We're going to look at 2 states that are recreational states. My thanks, and you're going to hear from Quest Diagnostics, who assists us in sort of the laws with what with also what sort of the positivity rate. So I'm going to tell you about what the status is in the states, and then let Dr. Sample talk about sort of what positivity, what trends have we seen. And we're going to start with Nevada. Nevada is what I call an old school medical marijuana state. It's been around, they've had medical marijuana since 2000. For those who are trivia, California went medical marijuana in 1996. They legalized in 2016. But that doesn't really tell much about the story. What it did in 2000 is it decriminalized it. That meant that people who were in possession of certain amounts and had a medical marijuana card couldn't be arrested. It was all about not being charged with a crime. And you see the first dispensary was not until 2015. Well, it meant that it was legal to grow it, but there was no place to go and buy it legally. We all know about illegal sales. And what you're going to find is that makes all the difference in the world. What is the access? Barry and I have worked on this, and we've come to the conclusion it's all about access, regardless of what the laws are. Nevada has limited marijuana card holders, 19,000. It is dropping, and we see that trend typically in states that go recreational. The number of card holders will, in fact, decline, even though there are good reasons, mainly taxation, where you might want to have a lot of card holders, but we don't see it. They have limited qualifying conditions. It's not like California where it's good for what ails you. You actually have to have a list of diagnoses. I'm not going to list them all, Crohn's disease, and we're going to talk a little bit about AIDS, glaucoma, things that you have to have a diagnosis to qualify for a medical marijuana card. So they legalized marijuana recreationally in 2016, and the first retail sale opens in July of 2017. So for data and for the law, that's like a nanosecond to go. So it means that we have data really 1 full year of buying it. Nevada has explicit employment protections. Some of the most difficult in the country. They added them for medical marijuana in 2014. It's an accommodation state. You have to see what the employer can accommodate. You can't have a blanket statement that they will not accommodate medical marijuana cardholder use. And this is what's making it really difficult. The Nevada legislature passed a couple months ago a pre-employment, effective January 1st, 2020. There will be explicit employment protections for people applying. This is applicants, pre-employment, who use marijuana. Yeah, that's what I said, that's right. There are a couple of safety-sensitive exemptions, and we're going to provide them to you, but you can't and no longer, it looks like, effectively just ban the use of marijuana and fire someone for a positive drug test, or actually not fire, refuse to hire someone affected that. We're going to see how that works. There's going to be law cases. There are, as I said, some exemptions. And you'll see the possession limits are different, and the taxes. So with that setting and the massive changes in Nevada, I'm going to turn it over to Barry to talk about what happens as we watch this.
Let me take this so I can make sure I get the pointer. Yeah. Okay, so I think the data is interesting as we look at our workforce positivity rates, and will really underscore the point that Faye was making regarding access. So we have data going back to 2012 here. So you see 2012, 2014, yes, there are some slow, steady increases. First dispensary in 2015 didn't really see an impact as we look at that 2015, 2016 data. So yes, medical marijuana was legal. Yes, there were a dispensary, but it really didn't move the needle on the positivity rate that we were seeing in our workforce drug testing. But look what happened in 2017 and 2018. So remember, the first dispensary was in the middle of 2017. Positivity rate went up almost 50% between 2016 and 2017, and it went up slightly over 50% between 2017 and 2018. So this really seems to underscore that it really is all about access, and it's not necessarily the legal status within that state.
Okay, so we're going to look at one other state that you would see should have some similarities to Nevada, and it's a very, very different thing. Washington is one of the oldest states to have legalized medical marijuana. It was legalized in 1998. But fast forwarding, it does know that the dispensaries aren't regulated until 2015. But the devil's in the details. That doesn't mean there were no dispensaries. It meant they were unregulated. In fact, what has happened is that there used to be estimated about 1,500 dispensaries for medical marijuana card holders in the state of Washington. There's now, I believe, 222. So it is, once with regulation and the state overseeing it, the availability of medical marijuana plummets. There's approximately 3,900 card holders, but I have to tell you, I can't really give you a good number of whether it's up or down because of the way Washington does their numbers. They include duplicate cards. They include a lot of different things that I don't feel really comfortable saying it's gone down or up. It appears to have gone down, but it's tough. They have limited qualifying conditions, just like Nevada. It's not open access. Some states, as you know, have any physician can recommend it. There's no prescription. Recommend it for whatever they think would be beneficial. This is a legislated list of qualifying conditions. So they legalized in 2012. They, along with Colorado, were the first state to do so. And the first retailer opened in July of 2014. Unlike Nevada, currently in Washington, there is no explicit employment protections. The Supreme Court has said that they do not protect it. So if someone has a medical marijuana card, right now in Washington state, and you as an employer say, nope, I don't think so, the law will support you on that. There is no employment protection under recreational as well. Nothing in there that we're aware of at this moment. You can see the difference in possession limits. You can have a lot more medical marijuana, and that's somewhat true across the states. And look at that tax rate. You have over a 43% tax rate if you have recreational, and you have zero. Yes, zero if you have medical. It's a little surprising there's not more medical, but remember what I said? 1,500 dispensaries down to 222? It's a big difference. So there is a thing where you have wide access. You've had access fairly continually, unlike Nevada. And now I'm going to let Barry say a very, very different picture when it comes to really what happens in the state.
Thanks, Faye. So, as you can see, a very different picture. So, recreational status, legal starting in 2012. Yes, we saw a bump, even though there weren't dispensaries. Yes, even though there weren't retail outlets available at that time. And we saw some slow, steady increases, but look at the data over the course of the last 3 years, even after the first retailer was open. I would essentially call that flat, which is unlike all of the other recreational use states. Washington really stands out as we look at state by state for these recreational use states, that it's flat. Not sure that I'd really call that a decrease, but essentially flat over a 3-year period of time.
Barry and I are both looking forward to 2020 so that we can look at 2019 data. One of the things we're thinking will be interesting to look at is particularly Nevada is it this expansive now available? Will we continue to see the big growth, or has it bottomed out? I would not pretend to guess. It's just the data is the data, and we'll figure it out. So what I want you to take away from this is the idea that every state is different. Don't expect the same experience. Don't expect the same reactions. Don't expect the same employee characteristics state by state. But the one thing we do see, and the reason we only talk about recreational states, and Barry mentioned this, is medical marijuana doesn't really move the needle. So let's now, with that mindset, we're going to go into for impairment, safety-sensitive concerns. What's happening about employment? All of us care about that. What's happening with medical marijuana? And some interesting and, frankly, disturbing changes when it comes to recreational. So impairment. So let me tell you some universal things that I think in the legislative minds give some great comfort when they sleep at night. Every single law on cannabis, whether it is recreational, whether it's medical, You do not have to let people use marijuana on the job while they're at work or work hours. And you never, ever have to let them work impaired. You just, in their minds, it's not a safety issue then. You see that? They're not impaired and they don't use on the job. Good, it's just like alcohol, let's move on. But what they've done is there's no per se limits, or very, very few in the United States. And the ones you're going to see up here, those are all driving under the influence. These are not employment levels, like when we see alcohol, a difference between sometimes the DOT or driving. These are all just driving under the influence. And you can see, so we have 6 states, and 6 states only, that have presumptions or per se in blood. Come on, folks. How many people here test in blood on their workplace employees? Yeah, that's what I thought. Nobody. So while this may be very helpful, and it has its own set of problems, there's no consensus, but it really doesn't help us in the workplace. We do have, and I want to point out, the recent legislation in 2 states does have some per se limits, again in blood, which you'd have to have, for 2 states on certain safety-sensitive positions, and those are enumerated. Sometimes safety-sensitive isn't what you think. So that's the legal landscape. No problem. But that's probably not the science. So I'm going to turn it over to Barry to talk about impairment on cannabis. Go ahead.
I think this is, yeah, okay, this is on. Just to remind everybody, and you've probably heard this before, and I'll say it again, there is no consensus standard. There is no objective measurement of impairment on the basis of a THC concentration in any specimen type, even in blood. And one of the things that further complicates it that people really aren't talking about is that when people use marijuana, depending upon whether it's smoked or it's ingested, you have different rates of formation of an active metabolite, which also has psychoactive effects. So unless you're measuring both parent THC as well as its active metabolite and trying to correlate that with impairment, you're going to miss the mark on trying to set a standard that is accurate and reliable.
What this means in the workplace is the fallback position of reasonable suspicion testing becomes critical. So one of the things is companion supervisor training, reasonable suspicion, that all becomes the things that will help you take your safety issues on the job, couple them with a drug test, probably oral fluid or urine, and start to make an impairment case. But you really need both, and so reasonable suspicion training for supervisors is absolutely critical when it comes to this. You're going to hear us do this, but let's move on. Can we get some exemptions? Because every question I'm asked is, but I employ crane operators. Clearly, this doesn't matter to me. All right, so here's what you're going to get today. I'm going to tell you about every state that I have what's called a safety-sensitive carve-out. And they're going to be in the appendix if they're not here, and we're going to give you them. What you're going to find out is they're not all the same. They're just not all the same. Every state does it differently. Not only do they have different positivity rates, the language in each statute is different. So I'm going to cover them, and you're going to see them. So New York City. Why are we talking about New York City? Because on May 10th, 2020, as it stands now, watch this space, New York City employers can no longer do pre-employment testing for marijuana. Got that? You cannot test unless, and only unless, they fall into certain categories. Police officers, peace officers, commercial driver's license, supervision or care of children. Probably not all the things that this group would like to have in their policy, but that's what got it. I will suspicion that these are the ones who showed up for the New York City Council meeting. You're going to find out when you read the notes that if you show up, you get your exemption. If you don't show up, it probably isn't. This is true even though there is no recreational marijuana in New York. It was quite clear the city council believed that they were going to pass it, and they just wanted to get ahead of the curve. But this is the one exception right now for private employers where, assuming nothing changes, testing will cease for this group. Tremendously vague at this point. Nevada, I mentioned already. We've traditionally only had some explicit employment protections for medical marijuana up till May of this year. okay? And, you know, yes, there's a lot of card holders. No, it doesn't really move the needle. Yes, employers can handle them as a one-off. Now we get two of them, and this is the first one, recreational. They have passed a statute applies to pre-employment testing where you can, we're going to talk a little bit about this, but you're going to see. But who's exempt from it? Firefighters, EMTs. Yes, they showed up. Positions that require operation of motor vehicles or which requires testing. Yeah, they were in the conference too when that committee met. And then positions that in the determination of the employer could adversely affect the safety of others. So everyone wants to know what that means. Well, it means you got some protection, but it also means there's likely to be court challenges about the extent and breadth of that. There is no easy answer on this one of what this is going to be. But you know what? I predict that courts and lawyers will figure it out. I do suggest, and we're going to get into the policy, job descriptions become critical. If you want to claim safety sensitive, make sure you have the data and the description covered. Arizona. This is medical marijuana only. It's not a recreational state. They have, again, certain ones, preparing food, handling medicine. Some certain ones that have it. And they take it, and this is through their method. You have to look at the statute. The first question, remember what is, where are your people located? Where are your employees located makes all the difference. Arkansas, medical marijuana only. Anyone involved in a safety-sensitive function pursuant to federal guidelines. Well, that's not a surprise. If it's DOT, obviously they're exempt from this anyway. It doesn't cover it. But they wanted to make sure you got it. Things designated by writing of employers. This one has some policy implications of not just what you designate, but how you designate it. And you can see there's more. Things that will lapse. Again, you have to take a deep dive and a look, because if you want to maintain a safe workplace, I think we'd all prefer that we could in fact not allow off-duty marijuana use. That may not be possible. So here are three more. New Mexico just has language. Oklahoma has a non-exhaustive list, and Pennsylvania and West Virginia have some ones. We're going to give you all these, and we'll give you all the links to them to be able to look at it so you can take it home and look at your one. But if not, there is no safety-sensitive carve-out. You've heard about them all that exist at this moment. It's not all 33 states, and let me assure you. So let's look at state medical marijuana laws. We're going to go through this fast. I'll get you in the appendix. You will have references to every single state so that you can double-check me and my math and my interpretation. So what are the trends? Yeah, it's going towards providing explicit employment protection. So certain states added it this year even. New Jersey just added. New Mexico just added. So that we have some states that had medical marijuana, and the legislatures are going back and adding employment protection. Again, in the early days, all people wanted to do was not be arrested by the cops. We've moved a long way beyond that. We also are looking, they're now providing other protections. Child custody. They're also expanding. Increasing access and reason restrictions. They are changing qualifying conditions for medical marijuana. One of my personal phrases, yes, you do see opioid use up there. 7 states, since we declared an opioid crisis in this country, said, I can solve our opioid crisis in our state. We can do it. Yeah, we just let it move to medical marijuana. 7 states have done it in literally a year, which for a legislative is incredibly fast. But then they can stand up and say, yep, we're doing it. We're taking care of that. The studies underlying it, I don't think they show causation, but I'll leave that to other people more qualified than I. Physician requirements. So that's in the trends. What do you have to look at? What does your policy have to look at? Medical marijuana laws, obviously we're talking about those. But you better look at other things, the disability laws. Remember, at least for medical, there is some health condition underlying it, unlike recreational. No, don't ask what the medical condition is. You don't want to know. This is all hippie information. But you do have to look, and there's been some case law that we're going to look at that kind of looks at that. FMLA. The one I want to focus on, let me see if I can do what Barry did. I don't think so. Look at the one.
Pointing at me. Point at the screen.
Point at the screen, Faye. Point at this screen. You know, I'm not very good at this.
No, up there.
There we go. I feel so proud. I feel so proud. Lawful activities, off-duty use laws. How many people are familiar with that? I didn't think so. That's why I got to go to law school. But what's an off-duty use law? Back a number of years ago, in the states that had a lot of tobacco growers, is where it started. So there was a lot of trend for people and employers wanted to ban people from smoking nicotine at any time. Not just, I mean, they obviously could stop them from smoking on the job. Impairment wasn't an issue. But they said, no, it's nasty. I'm a healthcare. I don't want to do that. And they did that. And a lot of state legislatures passed laws saying you couldn't penalize someone for engaging activity that was legal during their off-duty times. So you couldn't stop someone from smoking cigarettes at home, but you could stop them from smoking at work. So this is broadly caused, very basically what an off-duty use law is, and a lot of states have them. Some of them specify nicotine. Some of them just say legal under state law. Some of them say legal under law. So what does that all mean for marijuana? Oh, yeah. So let's use our favorite Nevada. Nevada has a off-duty use law that says you cannot penalize a current employee for activity which is legal under state law. That falls with our recreational. The reason I will tell you, we talked about the pre-employment Nevada statute that's going into effect. And of course the question is, why didn't they take care of their current employees? Because the committee thought they already had. They thought they had protection. This has not been tried in courts yet, but I can tell you the legislature believes it. So you always have to look at that as well. What's the workers' comp? Are you going to have to pay unemployment benefits? There's all these things. So when you talk with your in-house counsel and work with your legal team of where you're at, it's not enough just to look at the medical marijuana laws on this. You have to look at a lot of stuff. Okay, so where are we at today? How many states provide explicit employment protections, either in the statute or a Supreme Court of the state? 15. 10 of these are since 2010. This is a real trend. The extent and content vary all over the board. Certain states have said absolutely not. We're not accommodating and having to give employment deference to that. And that's 7 states plus DC. And then we have our favorite, the 11 states where, I don't know, maybe, maybe not. Either it's not addressed or it's not a final court decision, but you have to look at it and take the risks. This is at the core issue. You are weighing 2 types of risk: safety risk versus litigation risk. And depending on your workplace population, depending on your corporate mindset, these are going to be answered differently for everyone. I cannot tell you how to balance your risk portfolio. I can tell you where risks exist. So these are the ones that provided. We're going to put this in there of positive drug test language. As Barry just talked about, you know that it's no evidence of impairment to have a positive workplace drug test. So just because you have metabolites doesn't mean you're impaired. Safety-sensitive positions, we have a couple that have the levels we looked at. 1 Supreme Court decision. Some states have treated it as a disability, Nevada and New York. And some states contain exceptions. So that's sort of the trend. And in the appendix we're going to go state by state and give it all to you. So we're going to give you a couple. Some people here, we're in Texas. Oklahoma was a big mover, and they actually added a bill last year, and they passed for medical marijuana, and then had the Unity bill, and they provided explicit employment protection. But they did add exceptions for safety sensitive. But it's not exhaustive. What it means is going to be fought out in court, I guarantee you. New Mexico just added, as I told you, amended the statute. They applied it employment protection. So we don't have to decide what New Mexico is going to do, sadly. It moved from an uncertain state into, oh yeah, they got it covered. New Jersey, just a couple months ago, added it. And they're talking about adding it for recreational in their current proposed plan, just a little tipper of things to come. This is the one we talked about. Not only employment protection, absence of testing in New York. It amends the administrative code. I'm curious to see what will happen on this, since recreational is not legal in the state, but there's been no movement by the New York City Council yet. But it is exceptions. Now, we have some that have no protections. How do I know that? One is that we have state Supreme Court. This is for medical marijuana, don't forget, just medical. The Supreme Courts, and they're ones that typically are, I'm going to call older statutes were interested in decriminalization. But watch this space. California, for example, tried to pass it in the legislature to give employment protection. Didn't happen. Probably, these things tend to take a couple times. 2 statutes were just passed, Florida and Ohio, and it looks like they went really stringent to make sure there was no protection. And then we have ones that are adding it. Montana, Oregon, and Washington are trying. But it gives that. And then it's unclear. We have some intermediate court decisions or they simply have no language. And again, you have to look at other things and you have to weigh your workplace risk of what you want to do. So what does the case law look at? And this looks like there was some watershed because before 2017, there was no case that held that an employer had to accommodate medical marijuana usage, off-duty medical marijuana usage. And after 2017, all of a sudden, courts were finding it. And it doesn't really have, I don't think it has that much to do with the timing. It has to do with the fact that before 2017, they were looking at statutes that had no explicit employment protection. Colorado is the one we all remember who have been in this field. After 2017, they're looking at statutes that have explicit employment protection. And they are upholding it, despite the fact it's federally illegal. It's kind of the way it works. What's medical marijuana? Is it dead because of recreational? It actually is not. We have states actively. Some of these have recreational. Maine, for example, has recreational, and they still were passing changes to their medical marijuana law. And as we've already talked about adding hold on, can't do anything right. Yeah, I did. I went too far. I should never be trusted with these things. The expansion of qualifying conditions, you're going to see all of these added ones. They're actively working on this. And this isn't doctors generally saying. There are some physicians. But these are legislatures going, yeah, I think we ought to add this, or I've heard it. Very, very involved. So, recreational marijuana. Now, you've just seen from Barry, that's where the big ticket moves on positivity. All states that have recreational, the 11 of them, also have comprehensive. Be aware that not all 11 states have retail sales going on at this moment. We've said the ones that have passed. Every requirement's different, how much you can have. And here's my current favorite. 2 states have explicit employment protection. We've talked about the Nevada pre-employment that has a safety-sensitive carve-out. But let's take a minute, and we're going to get to Illinois and talk about it on the next slide. Everyone take a deep breath. And then 2 states, we're just not quite sure. Maine is not, there's no active sales yet, that are retail sales. It's not that you can. And Nevada current employees, I talked to you about what that's gonna be. But let's take a little look at Illinois. How many people have employees in Illinois? It may not be a great year for you. Illinois passed, and on January 1st, it provides explicit employment protection for off-duty cannabis use. Still, you don't have to let them work impaired. Don't have to let them use on the job. We heard how good that was from Barry. It gives up definitions of impairment. I got to tell you, it's still signs and symptoms. And it provides definitions for workplace and on-call. So we do not know what the regulations are going to say. I do not know. But I can tell you as it stands today. So crane operator, test positive for marijuana? Okay. Anybody that's not a DOT, at this moment, you are going to have to accommodate their legal off-duty use of non-impairing cannabis. So can they use right before they walk in the door? No. But you're still going to have to use signs and symptoms. This is, if I'm hearing one heartburn around the country, but this is a trend. How are we going to, as a safe work source, manage these states? And we'll answer questions the best I can. This is a changing landscape all the time. This was a big sea change. We'd never had protection for recreational marijuana like this. And then we've talked about Nevada. Interesting thing about Nevada, I'll see if Barry wants to add anything to this, is look what it says. Let me see if within 30 days, the applicant may submit an independent test after they test positive. This is pre-employment. Barry, what effect would it have to have a 30-day test to submit an independent other submission?
You mean like for the most commonly ordered drug test type, a urine drug test?
Yeah, give us a...
for most casual users, they're going to be negative in several days. So I think you can stay marijuana-free for 30 days and clearly pass that test.
What an employer has to do with that is unclear, but it doesn't make a lot of scientific sense. Okay, we're going to go through this quickly so that we can talk about policy, but federal marijuana laws, recent developments. We have for the first time a legal cannabis prescription. That would be Epidiolex, which is actually a CBD product. Has to have less than 0.1% THC, and that is now better reclassified. There's a lot of proposed legislation at the federal level over cannabis. Dozens of bills are introduced at each legislative session. It's hard to keep up with them, but it's also hard because most of them aren't going anywhere yet. Certain groups are certainly, you've probably heard about the banking, which is not exactly on the employment, but the part of the problem with cannabis industry is that you can't use the banks because it's federally illegal and illegal drugs, and they're trying to solve that. They do, just so we're clear though, we do not, the federal government does not enforce federal cannabis law where there is a valid state marijuana statute. So it's not, I get asked this all the time, why don't the feds just come in and clean it up? It's federally illegal. Yes, it is supreme power. The fact is, in the budget which passes, there is a specific amendment/rider, depending on which time frame you're talking about, to say that the Department of Justice can expend no resources. I can explain all the separation of powers to you, but the bottom line, do not be looking to the federal government to overcome state marijuana usage at this point in time. They're not going to do it. There is no appetite for that. Regardless of whether you like the taxation issue, whether they have the resources, there's lots of things talked about, but I don't see any change in that. Every time the budget expires, this expires with it, but so far every time they've passed it again. And then the biggest mover is in December 2018, the Farm Bill passed. Yeah, that's the next topic. You have to wait. We're not going to talk any more about it, but it was a big thing. That's a CBD issue. And this is where the FDA held a public policy on it. We don't have it. 3,000 comments were received. Nothing's really come out about it. We don't know when the FDA is going to sort of rule and make head or tails of this. Okay, so I'm going to now turn it over to Barry, because one of the things that I think is most interesting is now we have the laws. What does this mean for your workforce? So thanks to Quest Diagnostics, they have a lot of good data.
So on the basis of some of the things we've already been talking about, any predictions from the audience and what we might be seeing if we were to compare non-medical, non-recreational use state positivity versus medical versus recreational? How many people think that it's going to be higher across the board where marijuana is legal in some way? Raise your hands. Okay, you might be surprised by this data. So, 3 groups: the non-medical, non-recreational use states, medical only. Remember, Faye said that all recreational use states are also medical states. So the medical only would be simply that, medical only, and then recreational. And we can't really see it on this slide. There's a dash line with the national average. But if you look at that data, the non-medical, non-recreational, and medical states are tracking together very, very closely. And in fact, at least in our general workforce data, the medical states are actually lower now than the non-medical, non-recreational use states. But look at what happened in those recreational use states. In the medical states, we've seen a 30% increase since 2010 in positivity. Non-recreational, non-medical, a 35% increase, but in those recreational use states over that same period, a 71% increase in the positivity rate as compared with our overall national numbers of 70%. So this is the general workforce testing, private sector, company policy, but look at the federally mandated safety-sensitive testing. Similar type of pattern. Similar positivity in the non-medical, non-recreational, and medical states. Higher positivity, particularly in recent years, starting to separate out in the recreational use states. So again, similarly to the general workforce data, 25% increase since 2010 in non-recreational, non-medical, nearly 28% in the medical, and nearly 42% in the recreational use states, as compared with an overall positivity of about 28%, increase in positivity of about 28% for the federally mandated safety-sensitive workforce. But that doesn't tell the whole story. This breaks it out state by state for the recreational use states. Look at Washington. It's actually up 11% as compared with a 17% average on a, nationally between 2014 and 2018. Massachusetts, Colorado, California. When you get to DC, Oregon, Nevada is twice the national average for all of the recreational use states. So there's a significant state-by-state difference. It's not one size fits all. It really depends on where you are. This is data that is really new for us this year. We wanted to look at positivity rates on post-accident drug tests as compared with pre-employment drug tests. Historically, when we've looked for drugs like cocaine, drugs like marijuana, the more traditional drugs of abuse, we haven't seen any real differences in the positivity rates. But as you look at this data, we're seeing year-over-year increases in positivity rates on those post-accident drug tests, and look at the delta. In 2014, the difference in positivity rates between post-accident and pre-employment tests was 50%. In 2018, it had jumped to 71%. And for those of you with federally mandated safety-sensitive transportation workers, this should really be scary. Similar pattern in terms of the positivity rate, but the delta in 2014 was 19% between post-accident and pre-employment, and in 2018, it was 42%. Need to give a caveat. Correlation does not mean causation. I'm not trying to say that the positive marijuana test proves that they were impaired, proves that that's what caused the workplace incident that precipitated the post-accident drug test. But when you see those types of numbers and those types of differences, it certainly raises the suspicion that whether it's current use or historical use of these drugs may be a contributing factor. And Faye, I'll turn it back to you.
Thank you, Barry. So we have a lot of good information, but of course the real question is, what do you do now? Because guess what? You have to go back and you have to manage this. So let's talk about some factors to look at to have an effective marijuana policy in spite of immense differences and immense uncertainty. Let's give some guideposts and see some possibilities. So the first issue is, what do you have to consider? You have to know your workforce. And everyone always asks me, Faye, can't you just come up with one policy? And I said, I really can't. I wouldn't be doing you any favors. So, location, location, location. Where are your employees? Just where are your employees? So if someone says, well, I have a ton in Colorado, I'm going to do whatever you want. There's nothing that the Colorado Supreme Court said. If you want to enforce a zero tolerance for off-duty use, so far on medical, they've said you can. But what are the position and safety issues? I've had people want to tell me that people drive to work, so they're all safety sensitive. I guess that's true, and of course, I'm a huge safety fan. But if the legislature meant that, they wouldn't have put it in. So you're going to have to nuance it out a bit. What is their position? Are the receptionists or the people, the admin people, are they the same safety as people that working in nuclear reactors? I think we all know they're not. And I'm giving some dramatic, but you get to more nuanced of, are people working in a gas facility where they're going to be to it? I mean, this is where I mentioned you have to have your job description really well thought out so you don't overreach, but you certainly keep as safe as you can and try to balance that against the litigation risk. One of the multi-state issues, two things. First, if there's two types of multi-state is Employers who operate in multi-states, if you wish to continue to test and take action on marijuana positives, the days of one policy for all 50 states is really gone. I'd like to tell you differently. But you know, can you have one state? Sure, you can eliminate marijuana from your panel. I do not recommend that. But then you don't have to deal with it. There is no state that mandates you test other than for federally regulated. But be aware that you're giving up a lot of safety considerations when you do that. So that's one type of having a general policy. We will accommodate medical marijuana as required by law, and then do a state-by-state analysis. The other thing is what happens when you have an employee that works in multiple states. Much more difficult. And again, it's balanced. So if you want to be safe, you take the least restrictive state, the most employee-friendly, and apply that standard. If not, it takes a lot of individual legal analysis, where they're at, what they're doing. I mean, it's very, very nuanced. But for multi-state, you can do a couple of different things, but that's one of the things. What law applies? These are generally citizens, i.e. where somebody's a citizen of a state is what most of these are, but you have to know them. Know the law, and it's hard to keep up with. Know your obligations. Do I have to accommodate medical marijuana? That's the multi-state issue. And be aware that most medical marijuana laws don't talk about who's an employer or employee. This is the famous contractor issue that comes out. Those will be fought about in lawsuits. You know, who controls it? Who does it? So you're going to have some candid conversations, probably with your upper management. For those of you who are upper management, you know who you are. But what is my risk profile? How do I accommodate the idea we have a shrinking labor market? How do I get people? Do I have to accommodate? I'm a food service worker. I mean, these are all, it's the factors. How safe are they? How likely are they can they cause damage? I think anyone who's impaired can cause damage. But then again, it's a degree of distinction that you're going to have to look at and compare to the litigation risk. You know, there are some states that people simply sue more than others. But it's the tolerance an individual company has. And you can look at it and see whether you're likely to lose, but those are the easy ones. It's like, is this a safety-sensitive position? Those are going to be razor-thin decisions that have to be well thought out and documented. You have to have good job descriptions. And then I also think one of my big things, when I get with clients, my employer clients, and I say, what makes your policy the best? What makes it really work? Because I often talk to ones who really have good experiences. And they said, we're really, really clear with our employees. We are transparent. So what does that look like? So let me tell you that there are people who, your employees aren't lawyers. They're not. And they won't get the fact that medical marijuana or recreational is federally illegal, but okay in the state. And they're going to go, but it's my right. So if you want to take that perceived right away from them, be real clear. Give them the opportunity to do the right thing. Give them the opportunity to be a safe workplace. Tell them in advance, this is how we're going to monitor it. It's going to be the same with CBD. If you're not going to accommodate, let them know. Let people find out, make a conscious decision. Figure out how to administer it. I'm going to give a few tips on that. And then what are the consequences? So there are states where for a positive with a medical marijuana card, you might say, we're going to have to move your position. Or we have to arrange of when you take your drug. The problem with some of the medical marijuana cards is they use them on an ongoing basis. And beyond the scope of this talk, Barry could talk at length at how long a chronic user will test positive for marijuana. So it can be a long time. So those are the types of questions that you actually have to sit down and think about ahead of time. Because if you're transparent and clear with your employees, you're going to have less problems. They may not like it, but they'll be real clear about the consequences, and they won't be caught. Because a lot of them might say, well, had I known, and then just fill in the blank. Now, whether they would have or wouldn't have, we can all have opinions about. But give them the opportunity, and you're going to have a perceived better program. So you have to inform the employees of the policy and the reason of the policy. And I'm going to say this, apply consistent treatment. There's never anything as much fun as getting the call and saying, yeah, the CEO's son just tested for marijuana and we don't accommodate him, it's a lifetime ban, and we'd really like to find another way. Okay, but let me assure you, when it's not the CEO's son and you do the same thing, you're going to probably get a discrimination lawsuit. And this is true for all drug testing, not just marijuana. But apply it across the board because everyone wants to believe it's them personally when they lose their job. So inform them and the reasons, get their buy-in, tell them, explain to them you're making them a safer workplace, and apply consistent treatment. So what are the considerations? This is part of the process. What happens when you have an applicant claim medical marijuana cardholder status? I recommend to my MRO clients that what happens typically in today's world, and I assert, is it is still a positive. So the person says, the donor says, yeah, I'm positive for THCA, but I have a card. And the MRO will say, it has a decision tree, and it's really easy. And they say, would you like us to tell the employer that? Because remember, there's a health condition underlying it. They document it, they report it, and they put a comment on it, because the MRO is in no position to verify a card. You understand? Cards, and now, so then it comes back to you as a designated employer representative or your HR department. And what do? So you have documentation. You have to verify the card. What do I mean by verify? I do not mean call the state board. There is 1 or 2 states in this country where you could verify the validity of a medical marijuana card, but that is the exception, not the rule. When I mean verify, look at it. Is it expired? Is it under the right name? Is it facially valid? No more than when you have someone has a driver's license or a FMLA that you're going to go and try to go behind it. So you're just not going to get anywhere. Ensure the medical information. You do not know why they have a medical marijuana card, just as you don't want to know why they have to be off every 3rd Tuesday for what you'd later find out is their chemotherapy treatments. You just have to accept it, that it's been certified by the state and by the doctor. And make sure that we have any medical information, because this is medical, is kept separate from disciplinary channels, and keep it confidential. So those are beginning. We'll take some questions on this, but let's first do a summary, Barry. So why don't you talk about a first of these?
Yeah, so marijuana is at a 14-year high in our data, and we've seen increases or flat or mostly increases year over year over the last 6 years for marijuana positivity in our general workforce testing. And again, no drug test of any specimen type, hair, urine, oral fluid, breath, will tell you whether or not somebody's impaired. There is no correlation, no consensus data to support that.
Remember, marijuana is a Schedule I drug, federally illegal, and states are continuing to pass legislation for permissible uses. You see this total there. If there's one takeaway, it's it varies widely across the states. Do not assume that because you live in Colorado and have a handle on marijuana laws in Colorado that you understand what happens in Massachusetts. I guarantee you will not. Have a good workplace drug testing policy. Should apply with applicable laws. There's nothing faster than the employer's attorney going, yeah, that's not what it says in the statute. Be clearly written. Have good job descriptions. Have well thought out policies. Consistent application. Yeah, a consultant attorney. A lot of you I know would have in-house attorneys. Make sure they're engaged in your process. So with that, we're not going to go through the appendix. We will take questions if anyone has a question, and of course we'll be here later for the networking event. So,
sure.
I guess I'm still a little shady on jurisdiction. So let's say our office here in Houston hires somebody in Houston to send to a job site in Nevada. Did we not drug test them?
okay, let's ask the question.
Okay. So let's say our office here in Houston hires somebody that lives in Houston to go work at a job site in Nevada. Can we not drug test them? Who does the protection cover?
Well, this is where location. Texas has no drug testing law and no exemption, so you're perfectly happy to do anything you want in Texas. Okay? Now, so that is not a pre-employment testing in Nevada, as best we know it until we have a case law, because they are citizens at this moment of Texas. When they become a current employee in Nevada, because the pre-application is in Texas, they would have to be, and if, I'm assuming they move there or work there, you're going to end up having to abide by Nevada laws. It is very murky, but as of right now, on that unique one, but you have to look at both. You have to look at both. It is not, the multi-state issue is probably the most difficult issue there is. And if you want to be careful, let's imagine you're risk adverse and you don't want to have litigation. And your company says, I don't care what you do, but I just don't want to have any risk. You might apply Nevada law to them when you drug test and not take that risk. That's the risk aversion in your corporate policy, which I'll guarantee you everyone is different. But I can tell you Texas has no protection for anybody.
So
Good reason, bad reason, or no reason at all.
There's another one in the back.
Okay,
what
we're in
if-
the back.
Yeah, what if the same situation happens and they're pulled for a random, but they're in Nevada, and they pull up positive?
Oh, well, then if it's Nevada, and this is a very specific, so they're now working in Nevada, Nevada law is generally going to apply. And if you follow the legislature, they will believe their off-duty use law will protect them and you may not be able to do anything with no safety-sensitive exemption. But it's, what you would do is look where they're an employee of, what is the employment status, and what is the law in that state at the time they're done. That's the first, it's always about location. Because I'm assuming your thing is that do they live in Nevada? Ah, the multi-state. You probably, I will tell you, so if they're a Texas resident working in Nevada on a random.
Yes.
First off, I will tell you, as a part of your drug testing policy, you have to seriously consider whether you want to do random testing outside their state of employment. Give serious thought to that, because by the testing them random in another state, you're adding a nuance that might not be there otherwise. You see where I'm coming from?
Yes.
Okay, and that one, I would say that I would probably, from a risk aversion, might suggest you'd have to follow Nevada law. But a better policy would be to try to have people random, because this isn't federal now, to try to test them in their home state, because it eliminates the multi-state issue that leads to, and by the way, there's no court cases on this. It's incredibly difficult. It's hard. All right, any other questions? I know I'm holding you from the next slide.
If we have multi-state employees plus multiple category employees, would it lead, by having different policies, would that open us up to a discrimination suit?
Not as long as you're clear. So, and how I normally have my employer clients is, so it might say in the policy, accommodate where required by law, okay?
Okay.
Which is going to imply a difference.
And
But you have to let people know what category they're in. So don't be switching it. So people who, I don't know your things. People who answer calls from a call center, this is your job category. This is your drug testing program. If you're out on a rig, you may not be a DOT employee. This is your job category. This is your drug testing. So it has to be in advance, designated and consistently applied is the real things. And let people know this is all about process to make it clear. But where you get into trouble is, yeah, we moved him, so we ignored it. I know we moved him over there. Yeah, we should have done it and moved his category. Gets you into trouble every time.
Okay.
Does that help?
It does, thank you.
Okay.
Okay, so we'll be available during the.
Yeah, I know you all have it. And yes, I know we didn't cover anything on CBD. I promise you we will next. Okay, any other questions during the break? We're happy to. Thank you all so much. And the temperature got better.